The guiding principle in the exercise of constitutional jurisdiction is that the function of the court ultimately is to ensure the prevalence of the will of the electorate. If this is not so, public confidence in the electoral process will be heavily compromised. It is important that the public perception remains throughout that it is the decision of the electorate that has prevailed. In this election cause, the majority ought to have disengaged the mechanical gear of appellate jurisdiction and fully considered the evidence against the dictates of burden and standard of proof. The absence of time is not a sufficient excuse. The court has a competent institution of research and is well facilitated to be able to perform the role of an election court as a final verifying agent in cases of monumental importance, such as the present petition. Finally, I just wish to make a short observation on the following paragraph in the conclusion in the decision of the majority, where they said, let me quote, "Let this judgment then be read in its proper context. The electoral system in Kenya today was designed to be simple and verifiable. Between 8th August 2017, 11th August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It is obvious to us that the IEBC misunderstood it, hence its jumbled up reasons and submissions. Our judgment is also simple and our view clear and understandable. It ought to lead the IEBC on a soul searching and go back to the drawing board." The next sentence is where I'm raising my concern. If not, this court, whenever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same, irrespective of who the aspirants may be. Consistency and fidelity to the Constitution is a non-wavering commitment this court makes. Let me just repeat the words where I am finding I have consternation. If not, this court, whenever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same. These words, to my mind, are extremely unfortunate. I find it to be injudicious, it is imprudent. I reiterate in the strongest terms the following observation obtaining from my dissenting judgment in the Speaker of the Senate and another, in which I said, quote, "Just as Parliament is expected to operate within its constitutional powers, as an arm of government, so must the judiciary. The system of checks and balances that prevents autocracy, restrains institutional excesses, and prevents abuse of power apply equally to the executive, the legislature, and the judiciary. No one arm of government is infallible, and all are equally vulnerable to the dangers of acting ultra vires the Constitution. Whereas the executive and the legislature are regularly tempered and safeguarded through the process of regular direct elections by the people, the discipline of unappointed and unelected judicial arm of government is largely self-regulatory. The parameters of encroachment on the powers of other arms of government must therefore be clearly delineated, limits acknowledged, and restraint fully exercised. It is only through practice of such cautionary measures that the remotest possibility of judicial tyranny can be avoided. Having evaluated the entire bundles of evidence submitted by the parties and having checked the allegations made by the petitioner against the evidence, it is clear to me, had the majority been engaged in the mode of a court of exclusive original jurisdiction, looking at all the evidence, it would have found each and every allegation in the petition was addressed to a satisfactory standard, and where and if the burden of proof shifted, the Commission, that's the first respondent, discharged it satisfactorily. In view of the foregoing, had I been in command of the majority, And unfortunately, I am not. This would have been my determination. Having analyzed the various sections laid out in the rubric, having disagreed with the decision of the majority, and having consistently interpreted the Constitution to reflect the call of the Constitution's preambular paragraph that the people of Kenya, exercising their sovereign and inalienable right to determine the form of governance in our country, I hereby set down the following orders that flow from the ratio. 1. As to whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the law relating to elections, I find it was so properly conducted, and in particular with reference to Articles 1 and 38 of the Constitution of Kenya, and supported by Articles 2, 10, 81, 82, 83, 86, and 138. As to whether there were illegalities committed in the conduct of the said election, I am satisfied that there was no instance of fraud or illegality found or proven. 3. As to whether there were irregularities committed in the conduct of the said election, I am satisfied that any irregularities that were found did not favor any particular candidate and could not have impacted in any way on the result of the election. 4. As to whether the election was properly conducted by the first respondent in accordance with the Constitution and the laws related to the elections, I am satisfied that with all the attendant challenges of conducting a national election, that this was so properly conducted. 5. As to whether the second respondent properly declared the third respondent as president-elect in accordance with Article 138.4 and 138.10 of the Constitution, I am satisfied that indeed he did so. 6. As to whether the third respondent was validly and properly elected to the office of the President of the Republic of Kenya, I am satisfied from all the evidence assessed that he indeed was. Petition number 1 of 2017 is hereby dismissed, and each party shall bear their own cost.
Thank you, Justice Ndungu, for that long dissent. Can we please have order? I want to read one paragraph that I omitted, which I think is important for this matter. Regarding prayer 1, we have shown that IBC did not conduct the 8 August 2017 presidential election in conformity with the Constitution and electoral law. Irregularities and illegalities were also committed in a manner inconsistent with the requirement that the electoral system ought to be inter alia, simple, verifiable, efficient, accurate, and accountable. This is the important bit I wanted to repeat, or rather to read. Although the petitioners claimed that various electoral offences were committed by officials of the first respondent, that's IBC, no evidence was placed before us to prove that allegation. What we saw in evidence was a systematic institutional problem, and we were unable to find specific fingerprints of individuals who may have played a role in the commission of illegalities. We are therefore unable to impute any criminal intent or culpability on either the first or second respondent or any other commissioner or a member of the first respondent. We are simply unable to find any evidence of misconduct on the part of the third respondent. The prayer is therefore disallowed. On costs, we are aware that the costs generally follow the event, but the present petition has brought to the fore the need for IBC to adhere strictly to its mandate and not to exhibit the casual attitude it did in the conduct of the imbanned election and in defense of this petition. It is heavily it is heavily public funded, constitutional organ, and the burden Kenyan taxpayers with the litigation cost would be a grave matter which we deem unnecessary in this petition. Let each party bear its own costs. And with that, I want to read the final orders of the majority. By majority of 4, with Justice Ojwang and Justice Njokindungu dissenting, we make the following orders. A declaration is hereby issued that the presidential election held on the 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null and void. A declaration is hereby issued that the illegalities and the irregularities in the presidential election of the 8th August 2017 were substantial and significant, that they affected the integrity of the election, the results notwithstanding. A declaration is hereby issued that the third respondent was not validly declared as the president-elect, and that the declaration is invalid, null and void. An order is hereby issued directing the first respondent to organize and conduct a fresh presidential election in strict conformity with the Constitution and the applicable election laws within 60 days of this determination. On 1st of September 2017, under Article 140 of the Constitution. Regarding costs, as I've said, each party shall bear its own costs. I made a mistake to write Ibrahim's name, so it will just note. Yes, Senior Counsel.
My Lord, the first and second respondents seek directions arising directly from the majority judgment. My Lord, as the court has correctly directed, elections have to take place, presidential elections have to take place within 60 days. And I think as we sit here, we've got, I think, approximately 40 days.
How many?
I think 40. Is it 35? 35 days. So the directions we are seeking is that given the majority judgment, the ballot boxes for the presidential elections don't need to be preserved anymore. They are sealed, and we would like directions that the first and the second respondents can now unseal those boxes, and so that they can be used in the coming elections. We would be very grateful. Given the constraints of time, there is no reason, there is no rationale for not using those ballot boxes. There is no reason for continuing to have them sealed. The purpose of preservation has disappeared, and we would like to use those boxes in the coming elections.
How will the the record be preserved?
Well, the record is now the record of Your Lordship's judgment as far as the past election is concerned. It is the boxes that we need to use in the next elections. As far as the votes are concerned, those records in terms of Forms 34As and 34Bs are already deposited in court. This is important because if we don't use those boxes, that will impact on the capacity to have elections within the timelines set by the Constitution. I really don't need to overemphasize the point that public interest is what should guide this court in conceding to the directions that we are seeking. It is in the public interest that we as a nation, that the first and second respondents be able to conduct the elections within the timelines set in the Constitution.
Yes, Mr. Rango.
That's why we would not want to stand on the way, on the part of the first and second respondent to conduct the elections within the provisions of Article 140 of the Constitution. There is only one problem that the court may have to determine and deal with, that the preservation of election materials are not just for the purposes of an election petition. Because the election petition, principally for purposes of a presidential election, are had within 21 days of filing of the petition. Whereas the requirement for the preservation of the election materials is for 3 years, which in effect means that the election materials are not necessarily kept for purposes of an election petition. They are kept in our submission for purposes other than the conduct of an election petition, which includes even a member of the public within that period of 3 years may require to look at the election materials, the ones that are normally would be available for inspection, for purposes which include credibility without necessarily seeking a determination as to whether or not an election was held in accordance with the law and the Constitution. So the long and short of it, what I'm saying is that so long as a mechanism can be found to preserve, the election materials, some of which is in the ballot boxes, including the ballot papers, used or unused, all that materials, your lordships and your ladies, should be preserved even if the ballot boxes are going to be released to the first and second respondent for purposes of conducting the elections in the next 40 days. And that, of course, will reduce the cost if they're allowed to use it. But I think the fundamental principle which is contained in the law is that that material should be available and preserved for a period of 3 years. And we should not be seen to be violating that fundamental requirement of the law. Because I don't think this court has a discretion on that matter. I'm being reminded that some of those materials may be subject to other petitions. More significantly, the kits, or even the registers, if the manual registers were used, those would still be required by other courts in other election petitions. So subject to your directions, and depending on whether what I've said finds favor with the court, I think the order that would be commendable to the court, or should find favor, is not a blanket release of those ballot boxes, but an order also for preservation and sealing of what is contained in those ballot boxes.
Stangatia?
Yes, my Lord Chief Justice.
Yes.
We oppose the request by Senior Counsel on 2 grounds. First, my Lord, it is a legal requirement for all the material to be kept in situ in the condition the material is in for 3 years. That is a statutory edict for which this court is being requested to do away with. We oppose that request, my Lord. We should have fidelity to the same instrument, which is retain the material for the next 3 years. Number 2, my Lord, there are some very difficult matters that have emanated from the 3 judgments, which may require further processes. We have had this evening and the greater part of the day matters that we would wish to scrutinize in further detail. So all those materials, my Lord, ought to stay where they are without any form of adulteration or contamination. This country is large enough to be able to buy ballot boxes, which are plastic ballot boxes. We shouldn't here be talking of shillings and cents when we have nullified an entire presidential election and when a fresh election has got to be conducted. My Lord, I would urge you not to accede to this request because it may impact other processes which by law ought to be gone into, including what was the actual vote cast in the nullified election.
Yes, Mr. Mwite.
My Lord, briefly, the directions that the Commission seeks is confined to the ballot boxes, not the material. And I think that Senior Counsel Orengo perhaps is putting his finger on a way forward, because the Commission would be quite happy if this court so directs, to preserve the contents of the ballot boxes sealed, say in some other form, sealed. We are not seeking to destroy the ballot boxes or even the forms that are inside. We just wish to use the ballot boxes because every day, every hour is important as the time ticks towards the next elections, presidential elections, which have to be held arising from the majority decision. So the context can be preserved, and we have no problem with that. In a sealed form, could even be delivered for the custody in this honorable court, if your lordship so direct.
Thank you. Mr. AG, you are the protector of public interest. We would like to hear your views on that.
My Lord, I think I have a very simple observation that it is important that we comply with the law. And if the law says that material should be preserved for 3 years, we must do so. But this is one time when I am very happy to be counted with those who would like to look at the spirit of the law. I think the spirit of the law is to preserve the material, not specifically to sequester the boxes. Number two, my lords, I think that we have run a very expensive election. It has been set aside for the reasons that the majority have given. We should try as much as possible as not to incur further unnecessary cost. So I would add my voice to those who say, if a method of preserving the material can be found, including material being preserved here within the court, that would be preferable. And I thank you, my Lord, for requesting me to speak for the public.
My Lord.
1 minute, Senior Counsel. The Honorable, the Attorney General, is the ballot box an election material?
I would answer that in the affirmative.
Thank you. Thank you.
And the seal thereof.
Thank you. Thank you. That's all.
I just wanted, my lords, to explain.
Mr. Mwite, I mean, if we go on like this, where are we ending? I mean, you had
if you give me 1 minute, you will see that I'm saving the time of the court.
Okay.
Earlier, I had received instructions to seek the directions I did. right now, further instructions have come from my client, the Commission, saying that they will buy new ballot boxes. So I wish to abandon the directions. My Lord the Chief Justice, we've been sitting here since 10 a.m.
My lords, you do then write out the order as quickly as possible. Because another instructions may still come.
Sorry? No. I didn't follow Mr. Rengo.
No, I'm saying at the rate at which the instructions are being changed.
Yeah.
If you don't write the order fast enough, they may rise again with fresh instructions.
There's no need for any order. I think what my learned friend wants to say is that the court should rise as quickly as possible, so that we all go.
Could I, my lords? My lords, my legal team has requested me to make a very simple request to you, my lords. If it is humanly possible, please give us the electronic copies of the 3 judgments. I promise you, my lord, this is not an idle request. We'll spend the remainder of the night going through each of those judgments. Please allow us those electronic copies of the judgment.
It should be to all the parties, not to one party.
No, he spoke for you.
You're not doing the supply.
These lawyers are paid per speech.
hopefully the final order. Mr. Muite having withdrawn his application for release of ballot boxes, we make no order in that regard. As regards Mr. Ngatia's application for soft copies of the majority and dissenting judgments, we direct that the same be supplied by the registrar of this court as soon as possible. To all the parties.
Thank you. My Lord, it is Chief Justice, it is to express thanks on the part of the petitioner to convey our appreciation, Chief Justice, for your industry within the very tight timelines imposed on you for the management of this petition, for your constant patience in the face of, I must say, provocation to you, and your constant courtesy to us. And my lords, my ladies, we on this side extend our appreciation and give our thanks to each judge on this bench, including the absent judge, and we do so regardless of whether you allowed our petition or you dismissed our petition. When our courtesy in these circumstances extends only to those judges who rule in our favor, then we depart from a very important tradition of our profession. And we depart from being officers of the court when we don't only thank those people or those judges who have ruled in our favor. Instead, we become too close to becoming not officers of the court, but officers of preferred policy or political outcomes, which the court referred to earlier. Also, we tend to become too much like the English Premier League. Whenever Jose Mourinho loses, he blames the referee. And he thanks the referee when he wins. And I think that it is, when we are discussing these things in the bars, I say to them that the referee's word is final. As the court said a little earlier, a court's order is law, and the referee's order is law. But you know how fans are. They speak loud and very, very long and louder still. Then finally I pick up a newspaper, the Sunday's paper, and say, I think I should end this by referring to the report of the game. It says, look at the score line. The score line says 4-2. And the 3 points have moved somewhere else.
My Lord, my learned friend, Senior Counsel Firoz has spoken for the petitioner. I stand with the permission of the Honorable the Attorney General and on behalf of the Council of the Law Society to support the sentiments put forward by Senior Counsel Firoz Nauroji, to thank the court for the industry and the patience you have had with us. We, on behalf of my learned colleagues present and who have participated in these proceedings, we want to appreciate that you can sit continuously for, it is now going to 12 hours, And I hope that Kenyans will note this and see how hard and patiently you work for the truth. On behalf of my colleagues, we convey our gratitude. On behalf of my colleagues, we pray for the quick recovery of the Honorable Mr. Justice Ibrahim, who started with us and was unable to continue. On behalf of my colleagues and also of the Council of the Law Society, we wish to convey the very best wishes to every member of the bench. And as my learned friend has said, may the tradition grow that we don't just thank those who rule in our favor, but all those who give us something to think about, as have done all of you, my Lord Chief Justice and judges of the Supreme Court. Thank you.
Now order that the foot adjourned.
This doesn't look very nice. Okay. So I hope you are all okay. His Excellency will be addressing you shortly. Get this guy. Naomba kuja huku.
Usipeleke hizo vitu, acha kuja hapa. What happened to the rest? Hizo vitu acheni ya kuja hapa. The rest. Ambieni ya watu there's a setup here. Ulienda around, akaenda around.
You have not answered my question.
But hata hivyo hao wazee pia wako na nguvu. Tell forward. Akuje.
Anakuja hapa kweli? No. Then somebody should tell him.
I know it's been a long wait. We have sat in that court for nearly 12 hours continuously, including the judges. At least the advocates had moments when they could walk out for a break of 5-10 minutes, but the judges, all of them, sat from the beginning, from about 10:30 up to now, which has been a record 12 hours. I don't think in our history we have had a judgment or judgments read through this kind of period. But let me first thank our client, the petitioner, the two petitioners, the Prime Minister Raila Amolo Odinga and His Excellency Kalonzo Musyoka, for giving the legal team, a big legal team. I think we were more than nearly 30 lawyers and other professionals who undertook this work to prosecute this petition. It was not an easy task, and as you know, and as everybody has now come to acknowledge, that nowhere in the continent and in only 3 instances outside Africa has a presidential election been overturned. So I want to thank our team, which had very prominent lawyers, including senior counsels. I don't want to go through name by name. But I think we have proven that within the time stipulated for filing the petition and arguing the petition and coming out with a decision or a determination can be done. But we would agree with the sentiments that this law in relation to petitions should be looked at. But more important question is not just the victory that we have won. And I think this victory is a victory for the people of Kenya. It expresses the sovereignty of the people of Kenya, that them, through Article 140 of the Constitution, made it possible for any qualified party to challenge a presidential election, which must be held in accordance with the Constitution. But the big question which has come out from this judgment is that the court has found, with a majority decision of 4 judges, that there was systemic and systematic violations of the law within the IEBC. And what they are saying is that the IEBC as an institution has a problem, and it committed illegalities and irregularities which made it possible for this decision to be rendered. Some of those illegalities were clear violations of the law, especially in the transmission of the results. And in the very, very well-articulated judgment of the majority, a lot of questions were posed as to how some of these forms 34A and 34B, and even the final form 34C, which was used to declare the results, that all those forms were either forgeries. It was put in a rhetorical way, but they were either forgeries or they were not genuine forms which had been printed as required with this required security features. So on that account, it has been established by a majority decision of this court, and that is the decision of the court, that there are those illegalities, which now begs the question, is this the end of the matter? And our belief is that this is not the end of the matter. As you know, the chairman himself, consequent to what we raised in this petition,
and through memos that has now been in the public domain, he has himself raised so many questions which border on some infractions of the law and criminal conduct on the part of the officials, some of the officials within IEBC. And some of these questions were directed to Mr. Chiloba, and he has made an attempt, and you know the chairman is working in very difficult conditions. He has made an attempt to either suspend or dismiss some officials within the IABC for specific reasons, including the director of ICT and 2 officials who had unauthorized access to the database using the chairman's password or authorization. This is a matter that requires full investigations, and the Director of Public Prosecutions did promise that at the end of this case and after the decision has been rendered, he is going to fully investigate this matter and bring the responsible parties to book. In our view, therefore, the IBC headquarters is for all intents and purposes a crime scene that should be preserved and documentation and materials preserved for purposes of carrying out these investigations. On our part, on the basis of what we have, we are prepared to give assistance to the Director of Public Prosecutions to ensure that the IBC as presently constituted does not include those who have authored these unfortunate violations of the law. And I want to finish before I hand over to the Prime Minister that the country may be bordering on a constitutional crisis of grave proportion. A constitutional crisis in the sense that the powers that the president would normally enjoy were extinguished very substantially on the 8th of August 2017. And after the 8th of August, he was exercising temporary powers of incumbency. And the danger that we now find ourselves in is that if the elections are not held within 60 days, then he will not have the constitutional authority or legitimacy to continue to be in that office. If you read the Constitution purposively and have a constructive interpretation of the Constitution, Articles 138 to 140, you will find that the president, when not constitutionally in office, there would be a requirement that you have an acting president who is not the incumbent president until an election is held. So this particular constitutional crisis that we are getting ourselves into must be resolved as quickly as possible. And that can only happen if we have an election conducted in accordance with the Constitution. And the IBC is not going to run away from it, because the court has spoken very loudly that they cannot conduct any other election except an election held and conducted within the provisions of the Constitution. And they said that if the IBC does not do that, if another petition is brought before them, they will make the same decision. So we have got two competing requirements of that of holding the elections within 60 days from the 1st of September, or if an election is not held within 60 days, then the end of Uhuru's occupancy of State House or any other office, all other offices, physical offices, and constitutional powers ends at the end of those 60 days. I'm saying this because he did say that, he is still acting president until another president is elected. That is not the law. So with those remarks, I'll now call upon the Prime Minister to make his remarks.
I would like to thank the Kenyan judiciary for this historic ruling. But the ruling was done 20 days ago. But today they have given very comprehensive reasons supporting that ruling. As I said at the time when the ruling was made, it is historic for the African continent. We had an opportunity to meet with leaders of an association of African judges yesterday, and they all concurred with us that it is a beginning of a new era in the African continent. This is a major challenge to our country. And as I said last night, that the era of electoral autocracy must end in our country. In other words, that the people's vote must count. That Kenyans who have turned out to vote must know that their votes are eventually counted. Last time round, on the 8th of last month, millions of Kenyans turned out in the polling station to cast their votes. They, of course, expected that their votes were going to count. Unfortunately, by what has now been confirmed by the Supreme Court itself, those votes were manipulated at the tallying centers, at the constituency, and also at the national tallying center. And that therefore the vote did not amount to much. He said the computers then manufacture the leaders for the people of Kenya. This is what is unacceptable. And we now know that the same is what happened in 2013. And they used exactly the same formula to produce the leaders who are today shouting and hoarse their voices. They must know that they were beneficiaries of a very flawed process. And this is what they wanted to repeat again this time round. I am speaking on behalf of my colleague Stephen Kalonzo Musyoka, who was with me here, Honorable Salim Davadi, and Honorable Moses Wetangula, members of the summit of NASA. We have said that we are not afraid for another election. In fact, the campaigns ended and we are ready to go for the ballot. But we have said that we will not go to an election until the IBC rectifies all the mistakes which have now been confirmed by the court. Until those individuals who are responsible for these criminal acts are brought to book, removed and prosecuted. Then we are ready to go for elections within 60 days. We also have said that the KIM system that was used to manipulate these results must be rectified. That we have issues with a company called Safran Mofo, which was hired to provide those services. As you see, the court found the IBC and the service provider were in contempt of court. They were not able to give access to the servers as ordered by the court. Why? Because they were hiding something. This has been confirmed. The court also found that the forms that were used in recording the results were forgeries. They did not come from the printer. They did not bear the security marks which were required. We therefore have also issued with a company called Al Ghurair, which was contracted to print the ballot papers and the other materials used in these elections. We are therefore saying that we want another contractor to be appointed. Time is available for all this to be done. I would like to take the opportunity to thank Kenyans and all our supporters countrywide who have stood with us during these very difficult and trying times in our country's history. And those who support change in our country. I want to assure them that we are with them, that we will stand with them until we finally reach our destination. Our journey to Canaan was sabotaged by these saboteurs, but we are definitely on our journey to our destination. And when the time comes, we will be able to reach Canaan. And therefore, keep the hope alive. We shall overcome and we shall eventually achieve our objectives. Wafuasi wetu wa Kenya, leo hii mahakama kuu imetoa uamuzi wake. Uamuzi waliofanya wiki tatu iliyopita, leo wametoa maandishi ambayo imeonyesha ya kwamba ushindi wetu uliibiwa. Imeonyesha kwamba uchaguzi uliofanywa haikuwa wa halali, na imekashifu tume ya uchaguzi kwa kufanya njama ya kuharibu uchaguzi vile ilivyofanywa. Kwa hivyo imesema ati Uhuru Kenyatta hakuchaguliwa kihalali, ilikuwa ni ushindi wa bandia. Hivyo wamefutilia hiyo mbali na wakasema uchaguzi utarudiwa tena ndani ya siku 60. Tunatoa shukrani kwa mahakama kuwa na ujasiri na kutoa uamuzi wa haki ya kuonyesha ya kwamba Wakenya wana haki ya kufanya uchaguzi halali. Amekashifu tume ya uchaguzi. Amesema kulikuwa na maofisa pale ambayo walifanya njama ya kuharibu uchaguzi. Tunatoa shukrani hata kwa wale majaji ambao walitoa uamuzi tofauti. Hiyo ndio demokrasia, na kwa kufanya haya walisaidia demokrasia katika taifa letu. Tunasema kuna makampuni ambayo zilipewa kandarasi, kwa mfano ile ya kusambaza matokeo kutoka vituo vya kupiga kura, vituo vya kujumlisha kura na vituo ya kitaifa. Hiyo kampuni ya Kifaransa ambayo inaitwa Safran Mofu inaonekana ilifanya njama ya kuiba kura. Kwa hivyo tumesema hatutaki kuona kama kampuni hii ya Safran Mofu inabaki kama kampuni ambayo itasambaza matokeo ya uchaguzi. Tena kuna kampuni nyingine ya kutoka Dubai ambayo inaitwa Al Ghurair. Hiyo kampuni vile vile ilichapisha makaratasi bandia ambayo ilitumika, na hiyo sababu tumesema hatutaki kuona kama Al Ghurair ndiye itachapisha kura kwa uchaguzi inakuja. Sisi kama wananasa tuko tayari, tulikuwa tayari jana kwa marudio ya uchaguzi, lakini tutashiriki ikiwa kama uwanja itakuwa iko sawa. Tumeambia hata wapinzani wetu na wale na ile tume ya uchaguzi, tunataka kuona kama kiwanja hii yale mashimo na mahandaki yamezibwa, yale mawe yametolewa, yale miba yametolewa. Tumeng'oa visiki vyote katika hiyo uwanja. Ikiwa iko laini, tuko tayari kuingia kwa kiwanja, tuonane na wana Jubilee mundu humundu. Tuko tayari. Natoa shukrani kwa Wakenya wote. Habari macho, ziara yetu ilikatishwa ya kuingia Kanani. Tuko gengeni, na tuna hakika uchaguzi kurudiwa, tutaingia katika nchi ya Kanani, wapende wasipende. Shukran, asanteni sana.
Are you surprised, Mr. Orengo, are you surprised that towards the end of the ruling, the CJ has said that they did not find any criminal capabilities by any IEBC official or any member of the Secretariat, and so there will be no criminal proceedings against them?
And how would you move across with it now that they have said so as a coalition?
No, this is not a criminal court. An election court is not a criminal court. In fact, if you look at the laws that were amended last year and this year, we made the Election Offences Act a standalone act, which is within the domain of the Director of Public Prosecutions and other relevant government agencies. So once an election court has shown and demonstrated that there were illegalities, then it is upon the Director of Public Prosecutions to quickly move and take steps to deal with that problem. If you've read the Wetangula case, you remember they were referring to the Wetangula case very much. That is the principle which is there in that Wetangula case.
What if the DPP takes time in acting? What's the next move?
We had already said that if it doesn't act, then we intend to institute private prosecution. And already we are preparing ourselves for that. But within the week, we'll have a conversation with the Director of Public Prosecutions on that score. But there's something also I needed to say here, that, the election court said that the IBC, in response to the petition, they were jumbled. They didn't know what they were doing. Partly is because they did not appreciate the full effect of these laws that were changed last year. In fact, even Jubilee, I think, were living in another world until we came to court. Some of these changes that we made, courtesy of the election laws that were changed last year, at the end of last year and this year, has made it possible for us to get footprints of these violations. If it was like the elections which was held in 2007, it was very difficult to get those footprints. But this one, you can see even the court is saying the best thing for IEBC would have been to open up and then prove the point that they had conducted the elections fairly and transparently. But they don't want to open those servers because they know that if those servers are opened, then I can confirm that Raila Amolo Odinga will be declared the winner of that election. So they will never open it for that reason. Yeah.
Now, if I told the 60 days elapsed and there is your demands have not been met, now what will happen?
Then he ceases to be president. He will not have authority, constitutional or otherwise, to act as president. That status and capacity ends at the end of 60 days. because thereafter there will be no fresh elections held in accordance with Article 140 of the Constitution. It will be a hunt for a new president of Kenya, and not Uhuru Kenyatta.
Tosha gari, wacha washuhudie watu nje.
Excuse, yes, please ask.
If the results are verified as they can be electronically, so there is no room for any fraud. No? So now I'm asking, why do you think that it's so important how to change some officials when you have these laws who can guarantee that even if they are criminals, they will not be able to change the results if it's done as the court has demanded? All these scanned copies of the 34As.
If it is done properly in accordance with the law now, you cannot have a better election. This new system of elections, as established under Section 44 of the Elections Act, is the best for Kenya to guarantee a free and fair election. But my worry is if...
Why you still say that certain officials have to be in order to go to elections? Now we are also thinking that maybe you prefer 60 days
separated by human beings
without elections.
The law requires if you commit an offense, you have to be arrested and prosecuted. You cannot have criminals running an independent commission. They have to be taken away. No, it's a condition for the elections. Yeah.
The issue is this. I think the question is asking is why do we have to change some of the officials if the laws are so clear? Are you listening? Yes. The reason we have to change those officials is because they failed to follow the law in the first place. And if they are not changed, despite the law being good, they might refuse to follow it again, and we'll end up exactly where we are. And that's why they must be replaced with those who respect the law and will follow the law. I think that was your question.
Do you have a desired timeline that you would say by this date, within these 60 days, there would be your demands would have been...
No.
It's a repeat.
I think that question has been answered.
His Excellency.